Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about 212H waivers. Now, I actually did another video this morning regarding 212H waivers, but the mic was off, and I'm just making sure it is not off now. Okay, it is on. Thank you to the person that gave me the comment that it was muted. So I will just summarize again essentially what the waiver is now. Basically, we're talking about somebody who wants to become a lawful permanent resident and has committed a crime, okay? And the crime makes them inadmissible to the U.S. So there's issues as to when the crime was committed, what type of crime, whether it's a crime of good moral character, whether it falls under this provision. Again, there are a lot of different procedures and issues dealing with this, but for purposes of this video, I would like to just talk of filing of the 212H waiver, and you just need to keep in mind the following. You want to get your green card, you committed a crime of good moral character, and you think you may apply or get a waiver. And a waiver, if it's approved, basically says, okay, we, immigration, have looked at this, attorney cover letter, declarations, affidavits, evidence, all this other stuff, and we feel that we're going to forget about the crime and let you get the green card. That's really what the waiver is. And the waiver is very important because it actually opens the door for you to be able to adjust status. So some of this depends on where exactly you are living, where in the U.S., because while immigration law is federal law, the reality is that different jurisdictions apply the law differently. Okay, that's not true in every case or all cases, but in this particular respect, it is. So if you live in the Ninth Circuit, which hopefully you do, the law is the best. Okay, it's applied the most liberally. The decisions are well written, all this other stuff. Not that they're not well written in the other jurisdictions, but if you happen to be in the other jurisdictions, some of the options are not open for you. Okay, so let me give you an example. This is an example of where somebody has committed, for example, an aggravated felony. Okay, and there's all kinds of issues as to what is an aggravated felony and what's not, how you do the categorical approach and modified categorical and all that. But let's assume for argument's sake that it is an aggravated felony. Well, when you look at the 212H statute, it specifically says if you have been admitted to the U.S. as a lawful permanent resident, you can apply for the 212H waiver unless you have committed an aggravated felony. So just based on the face of that statute, that you can apply for a 212H waiver. However, there's some issues. If you, and this actually applies everywhere. Okay, if you still have never adjusted status and you entered the country illegally, has long expired, and you committed the aggravated felony, then the statute doesn't apply to you, or the particular item in the statute doesn't apply because you were never admitted as a lawful permanent resident. So therefore, if you have never been admitted as a lawful permanent resident and committed the aggravated felony, you can do the 212H waiver. But then the issue comes, what happens if you entered the country illegally, with some kind of visa that expired, and then later adjusted status, got the green card, and then committed the aggravated felony? Okay, so do you see the difference? The first example was you never got the green card no matter what, and you basically entered illegally or with a visa that expired. Everybody's eligible to apply for the waiver if you have an aggravated felony. The second example is the same, except at some later point you applied for adjustment of status, and then you committed the crime. Well, in a lot of jurisdictions in the U.S., the moment you applied for the adjustment, your admission, you were legally admitted to the U.S., and therefore you cannot qualify for the 212H waiver. Except in the Ninth Circuit, and actually some other circuits too, depending, if you adjusted in the U.S., but you entered the U.S. as other than a lawful permanent resident, then you still qualify to apply for the 212H waiver, even though you previously applied for adjustment, even though you previously got the green card, you still qualify for a 212H waiver. Okay, so if not that you should forum shop, but if you happen to be in a jurisdiction that doesn't go by that rule, and you're going, to be in a situation where you're going to have to be applying for the waiver, you might want to move to the Ninth Circuit or a circuit that follows that particular regard. Okay, so that essentially is how you are able to apply for a 212H waiver, even with an aggravated felony. Now, let's say that in other situations you have a crime that you committed more than 15 years ago. Okay, and then we're not talking now about aggravated felonies, just any particular crime of good moral character, and you want to apply to adjust status to get the green card. Well, instead of doing the normal extreme hardship 212H waiver, where you have to have the qualifying relative and you have to show all of these other items to show the extreme hardship, you can apply for the 15-year 212H waiver, which is considerably easier. You don't need any qualifying relative. You basically show you're not going to be a national security risk to the United States, and it's not against their interest to allow you in. And basically, the burden is much lower on that. So if somebody comes into my office and they need a waiver, 212H waiver, and I find out they did the crime maybe 14 years ago or 13 and a half years ago, it might be worth their while to wait a year and a half so they can get under the other provision. Or we can apply for the regular waiver. If for whatever reason it's not granted, by the time we find that out, it'll be almost time to apply for a waiver based on the new, the newly found, the 15-year provision. So in that particular regard, you can see there's lots of intricacies with this waiver. I mean, you can even apply as a standalone waiver without the AOS should it be necessary. As far as the 7 years physical presence needed in order to apply, it depends what jurisdiction you are as to when the 7-year begins, and whether it begins when you entered the U.S., whether it begins when you apply for adjustment of status, whether it begins when you're a lawful permanent resident. It all depends. So if you basically, bottom line, if you have a crime, you're not sure what waiver, or if you qualify for one at all, go ahead and give my office a call. I'll give you a free consultation. And anywhere in the U.S., it doesn't matter. I'll just determine what jurisdiction you're in, and what particular waiver you can apply for, and what the best way is to do it. Okay? So more on the coming videos. Thank you.